So, good evening, students. I hope you're doing well. Today we'll be discussing some of the conceptual topics of polity. Okay, some conceptual topics of polity that we left behind the other day. I got a query from a few of the students that they are finding it difficult because we are having a Hindi explanation. So, what from this lecture, what we're going to focus is on, we'll try to focus on English as well as Hindi, because some of our students are also from the Hindi medium background. So, as you all know, the language of the text is English, but the explanation is in Hindi. So, it was in Hindi in the previous videos. So from now onwards, what we'll focus on, we'll use both Hindi and English here, but our prime focus would be on English. So whenever I'm explaining any of the concepts in polity or history or any other language, our prime focus would be on English here. There are different faculties who are also teaching, so I requested them to continue with focus on English as much as they are focusing on Hindi, so that students who find it difficult to understand Hindi can understand English and can understand the different concepts that are being taught here. So the first concept that we'll be talking about is different constitutional bodies that are there in India. Okay, first constitutional bodies. The important constitutional body are, one is ECI, that is Election Commission of India. Then is CAG, Comptroller and Auditor General. Union Public Service Commission, the exams that you're preparing for. State Public Service Commission, that is the state service exam. Finance Commission, and National Commission for Backward Caste. There are other constitutional bodies as well, like National Commission for Scheduled Castes, National Commission for Scheduled Tribes and all. So we have not mentioned that here because although they are important, but from exam-centric point of view, you can skip those things. So the constitutional bodies that we are focusing here today on: Election Commission, CAG, UPSC, SPSC, Finance Commission, and NCBC. So recently, as you all know, 15th Finance Commission was set up, and it is set up for every 5 years. So when we focus on Finance Commission part, I'll be getting more into the details. Key Finance Commission, what are its main work in relation with the daily functioning. So the first thing is, when talking about the Election Commission, Article 324 deals with Election Commission, and State Election Commission, Article 243 deals with it. When I'm talking about the appointment, so President appoints the Election Commissioner, and the Election Commission of India is a multi-party body where 3 members are there. So in 3 members, one is the Chief Election Commissioner as mentioned here, and 2 are other election commissioners. The age and tenure of the Chief Election Commissioner is 6 years or 65 years of age, whatever he attains first. So suppose if a person who's 59 years of age and he has been selected as the Chief Election Commissioner, he will continue to serve the office till the 6 years or till the time he attains 65 years of age. But if a person is selected as a Chief Election Commissioner at the age of 63, so he will only serve as a Chief Election Commissioner for 2 years, that is till he attains the age of 65. He won't be continuing his 6 years complete tenure. So I hope this concept is clear. Next is, there is security of tenure. Security of tenure as in, you cannot take steps, to reduce his salary or allowances that are given to him once he's selected. And in order to remove him also, there is a special, you have to go through special process while removing him. And the removal can only be done by the President. In State Election Commission also, the removal is done by the President. The only difference I would like to mention here is, when I'm talking about the Election Commissioner, so the main primary focus of the prime work of the Election Commissioner is conduct free and fair election. When I'm talking about Election Commissioner as a whole, so one thing you have to keep in mind is that why the Election Commissioner or the Chief Election Commissioner, CEC, along with the Election Commissioner, his focus is basically on conducting the election of, or rather for, State Legislative Assembly, Parliament, Lok Sabha, that is, Vice President, and the President. The work of the State Election Commissioner, SEC, is nothing but to conduct elections at the Panchayati Raj level. Okay, so whenever the 72nd Constitutional Amendment Act comes into play, it means it mostly speaks about the Panchayati Raj institution election. Okay, so the work of the State Election Commissioner is not to conduct the election of State Legislative Assembly, rather its function is to conduct the election for what we call it as Panchayati Raj institution. Next, when we come down to Election Commission, its the main focus is conduct free and fair elections. Secondly, it's a quasi-judicial body, that is, disputes relating to merger and all those things could be solved by the Chief Election Commissioner along with election commissioners. Okay, but it cannot, it cannot disqualify a member. It cannot disqualify a member from contesting election. All these things are done by the Supreme Court and all the other parties. Okay, so Election Commission basically deals with conducting of elections and disputes related to merger of parties or getting that election symbol, all those things. When you come down to CAG, CAG comes under the Article 148 and he's an executive body. First, audit government bodies as well as private and professional bodies. So, ये क्या करता है आपका audit करता है government bodies को as well as private bodies को भी. Secondly, when we go more into detail, CAG, about the CAG. So again, that was mentioned here about the Election Commissioner, that there's a security of tenure. Same goes for the CAG as well. Okay, and one more thing is that even though Election Commissioner or the State Election Commissioner can be reappointed in the government services, but when I'm talking about the CAG, there's a cooling off period for him. There's a cooling off period. That means once you are selected as a CAG, selected as a CAG, and once your tenure is over, you cannot apply for any other government services as such. So there's a cooling off period in terms of that. No, you cannot apply for any other post that is in private sector or government sector if you retire as a CAG. Now we come down to your courts, that are Supreme Court and High Court. So these Supreme Court and High Court both have the power of the contempt of court. So contempt could be civil as well as criminal contempt. Okay, and when we are talking about the civil and criminal contempt, so recently there was a case regarding this Prashant Bhushan, who was a lawyer, and he not recently, I think it was a couple of years back, 1 year back, when this Prashant Bhushan, he's a lawyer, he commented on the then Chief Justice of India, Sharad Arvind Bobde. He commented on him that he was riding some bikes and something like that. So that time, criminal contempt of court was imposed on him, but later he was freed from the charge just by a penalty of ₹1. Okay, so the contempt of court powers are both with the Supreme Court as well as the High Court. Now we see what are the different jurisdictions of Supreme Court and the High Court that are present. So the first thing, jurisdiction, it has a original jurisdiction and exclusive jurisdiction. Supreme Court in issuance of whip. It's not writ, it's whip. Okay. So habeas corpus, mandamus, prohibition, quo warranto, and certiorari are different kind of whips available to the Supreme Court and the High Court. Yeah, so it's not whip, it's writs. Okay, so different kind of writ. Whip is a different thing. Okay, whip is basically, it's an office in the parliament where a particular person is chosen from that particular party to look after, the various issues like attendance of the MPs, whether they have voted in the parliament as in the favor of the motion and all those things. We'll come to that when we study the whip. As of now, it's not important. You can skip this part. So there are different writs that are mentioned in that are available to the Supreme Court as well as the High Court. So some of the writs are, it's not WHITS, it's WRITS writs. So habeas corpus, mandamus, prohibition, quo warranto, and certiorari. So one thing I would like to tell you that Supreme Court can issue writs only in the case of infringement of fundamental rights. But High Court can issue writs in case of infringement of fundamental rights as well as infringement of legal rights. So remember this thing. Okay. So when we are talking about the writs part, the Supreme Court's writs jurisdiction is High Court's writs jurisdiction is broader than the Supreme Court's writs jurisdiction. Okay. I hope this is clear. So many times you can get confused that because Supreme Court is a higher authority, that means its writs are the power to issue writs are higher. But no, the writs authority of High Court is broader as compared to the writs jurisdiction of Supreme Court. Next, there are appellate and advisory jurisdiction, and there is revisory jurisdiction. Okay, so these are the jurisdiction. Next is writ jurisdiction of High Court is greater than the Supreme Court, as I told you. Next, when we come down, writ jurisdiction of High Court, Supreme Court, compare competitive federalism. When we talk about the competitive federalism, it talks about the bottom-up approach. Okay, it talks about the bottom-up approach. But when we come down to cooperative federalism, it talks about the trickle-down approach. Cooperative means when we are cooperating with the neighbor states and working together. Okay, working together. But when we're talking about competitive, we are having a kind of competition with our states, our neighboring states, in order to stay in the forefront. And as a result, there is a competition among different states. So it's a bottom-up approach where we go from down and addressing a particular issue. But when we are talking about cooperative federalism, it's basically a trickle-down issue. That suppose funds are allocated for a particular cause and to the center or to the ruling authority, and then these funds, they trickle down. Next important concept is the concept of ILP, that is inner line permit. So always remember the ILP is available. Inner line permit pass you have to take if you travel to these states. So what are these states? Arunachal, Nagaland, Manipur, and Mizoram, and some parts of Andaman Nicobar and Lakshadweep. Don't get confused with 6th schedule state. So 6th schedule states talks about administration of tribal areas in the areas of tribal areas in the states of Assam, Meghalaya, Tripura, and Mizoram. So the Mizoram state is common both for the ILP as well as for the 6th schedule. I hope this is clear. Now, as we go down, 5th schedule, yeah. So 5th schedule talks about administration of tribal areas in all the states except those states that are mentioned in the 6th schedule. So administration of tribal areas in all the states of India comes under the 5th schedule, and administration of tribal areas in these 4 states comes under the 6th schedule. So interstate river disputes also could be addressed, has been rising over the last few years. Okay, you can skip this thing. Next is Article 35A. So Article 35A was added and removed by the presidential order when this Article 370 was removed. So remember that Even though Article 370 was, the provisions of Article 370 was removed from the Constitution, even though Article 370 continues to be into existence in the Constitution. Okay, the provisions have been removed from Jammu Kashmir, but it continues to stay there. Property rights in Jammu Kashmir, only Article 18, Article 370 is applicable to Jammu and Kashmir before 2019. So what are the provisions of this Article 335A? It differentiates permanent and non-permanent residents. It is not there in the original Constitution, this Article 35A, nor added by the Constitutional Amendment Act. The 35A was not there in the original Constitution as well, and it was not added through a Constitutional Amendment Act. Rather, what happened was it was added through a presidential order later on, and so it was removed accordingly. But it came into being due to Article 370. How it came into being? The Article 35A after 370 was added, where special provision was given to the state of Jammu and Kashmir. Next, when we come down, Domestic Worker Convention is related to your report of ILO, but India didn't ratify till now. India hasn't ratified this till now. Okay, so India hasn't ratified, but it has signed the document that of International Labour Organization, this Domestic Worker Convention. India is the founding member of ILO. Always remember this. What is enemy property? Those property that are owned by countries that India has war, or India doesn't have a friendly relations with. So if I'm talking about the enemy property, which are the states that will come under this enemy property? So Pakistan ho gaya, yeah, China ho gaya. These are the states that comes under the enemy property criteria. And Ministry of Home Affairs, MHA, to control over them. So Ministry of MHA decides how these states, how to deal with the enemy property that are present in India. So there is a body also formed under the MHA, that is SEPI, Custodian of Enemy Property in India, that looks after what will be done by those property that are owned by the citizens of Pakistan and China. So it's a quasi-judicial body again, as I told you. Okay, so now some of the basic concept I would like to mention, that article right to protest without arms comes under article fundamental right, article 19 of the Constitution, 19A rather. Okay, in scheduled areas, next is important is in scheduled areas, example Nagaland, you can't give 100% reservation. So 100% reservation is not given. National Security Act, Umar Khalid was detained under this act recently, so it was in news. National Security Act. State flag, about the state flag concept. So Constitution of India under SR Bomai case has told that a state can have its own flag. A state government or a particular state can have its own flag, but when the particular flag is raised, okay, when the particular flag is raised and when the flag of India is also raised, that means at that situation, the flag of India would be at a higher pedestal as compared to the state flag of that particular state. So having a state flag is not a problem, but when you raise the flag, it should be at a lower pedestal as compared to the national flag. And flags comes under the residuary list. Okay, so under the 7th schedule, there are 3 lists, that is the center, the state list, and the concurrent list. So under the 7th schedule, and those subjects that are not mentioned in all the 3 lists, they comes under the residuary list. So flag is a subject that comes under the residuary list. I hope this is clear. What is defection and anti-defection? So as you know, 10th schedule was added. So previously what used to happen, that some of the MPs and the Legislative Assembly members, what they used to do, they used to contest elections on the they used to contest election on the tickets of a particular party. Say if I'm a Congress citizen, if I'm a Congress member and Congress party gives me the ticket, and suppose I win the election. Now what happens after coming to power, what I have realized that the BJP party members, they come to me and they tell, I'm just giving you an example, okay, don't take it otherwise. So BJP members comes in and tell me, okay, Mr. XYZ, we will pay you 1,000 crores. What you do, you leave this party and join our party. And once you join, even after paying 1,000 crores, we will make you what? We'll make you one of the MPs in the, we'll make you one of the cabinet ministers in the government. Okay. So now I realized that, okay, even though Congress is not in power, so it's better I join them and I become a cabinet minister. So previously what used to happen, that when minister used to shift their party easily just by, because there was no law as such that used to prevent them from doing so. So after this law that came up after the 10th schedule was added, 86 Constitutional Amendment Act, after it was added. Yeah. So yeah, it was not 86. Okay, it was not 86. What the actual was 52nd Constitutional Amendment Act 1985, through which the 10th schedule was added and where the anti-defection law was added. So one thing we have to remember: Speaker has the authority to determine whether a defection has taken place or not. So remember this point. Okay, I'm just going through the surface knowledge of different topics. I hope you have done your previous revisions. Okay, I'm just discussing the few statements because I hope you know what is defection, what is anti-defection, and then accordingly you have to take into stride this statement which tells about Speaker has the authority to determine whether defection has taken place or not. Then leader of opposition. When we talk about leader of opposition, it's a statutory and not a constitutional body. Okay, it's not constitutional in nature. It's leader of opposition. It's just a statutory post that is given. And how do you get this post? Once the party that scores the second highest number of votes, if it's managed to win 10% of the seats in Lok Sabha and Rajya Sabha, they would be, that party person would be recognized as the leader of the opposition. Currently, Adhir Ranjan Chaudhary is the leader of opposition in the parliament. Next is impeachment of president. Okay, impeachment of president. We'll talk about this in the later stages. Now let's focus on private member bill. So private member bill is a bill that is introduced by a member of the parliament who is not a cabinet minister. So when a bill is introduced by the member of parliament who is not a cabinet minister, we call it as a private member bill. UTs except Delhi and Puducherry don't have a representation in Rajya Sabha. So when I'm talking about the Rajya Sabha representation, Delhi and Puducherry, and now Jammu Kashmir also has a representation in Rajya Sabha. Okay, except these three union territories, no other union territories have representation in Rajya Sabha. Floor test is conducted by the speaker and called by governor when he feels government in power has lost confidence. So every state, in order to check whether the ruling government has still enjoying the power, how does it happen? The governor calls for, to carry out the floor test, and who carries it out? The speaker carries it out. I hope this is clear. Next is floor test by governor. Confidence motion moved by the government. No confidence motion is passed by the. So remember these three facts, that floor test, the proposition is done by the governor, proposed. So as a result, floor test is conducted by the speaker and called by the. So the governor proposes the floor test, and governor proposes the floor test. Speaker conducts it, and confidence motion is moved by the government. Okay. And no confidence motion is moved by the opposition party. Always remember this. Whip is a person on that particular party who ensures that attendance is carried out. Okay, attendance ensures attendance of all the MPs, regulates the behavior of the member parties, and again, it's not mentioned in the Constitution of India. So remember this fact: the post of whip is not mentioned in the Constitution of India. Like somewhat same like the what you can say, the leader of opposition post is also not mentioned in the Constitution. Similar to that, the post of whip is also not mentioned in the Constitution. Again, contempt of court, I told you, there are civil contempt and as well as criminal contempt. Next, we come down to curative petition. So the concept of curative petitions was introduced in Rupa Ashok Hura versus Ashok Hura case. And this curative petition again is not mentioned in the Constitution of India. It is the sole authority of Supreme Court to review or consider its judgment when appealed for. So suppose a Supreme Court, gives a judgment to hang a person or any judgment. Again, when that person feels that, okay, there is some mistake by the Supreme Court, or I want to question the judgment again. So he can ask for the curative petition. Curative petition ka curative petition ka feature that is there. Okay, so he can ask for it, and as a result, the Supreme Court can review his or her own judgment and consider its judgment when appealed for. So it's sole authority, or it's the sole jurisdiction of Supreme Court to go ahead with the curative petition. If Supreme Court feels that it's not required, they can cancel this. Okay, taken into account after review petition. So first review petition is filed. That is not mentioned in the Constitution. Then the curative petition is filed. Okay, to review the judgment, to review petition is filed. Again, to review the judgment, the next process is the curative petition, and this was introduced in Ashok Hura and Rupa Ashok Hura and Ashok Hura case. Article 370, gives special provision to Jammu Kashmir in terms of all provisions of the country are, not a single provision of the Constitution of India is applicable to Jammu Kashmir when the Article 370 was present, except in the matters of security, trade, commerce, communication, and external affairs will be looked after by the central government, not local government, by the central government. Okay, so now we lay down rules for post-retirement hiring by officials. So once official who's a government official, he retires from a government office, so Central Vigilance Commission has laid down certain procedures that the particular concerned person has to take, clearance from the Central Vigilance Commission after he is retired from a particular government organization and wants to apply to a different government organization. Okay, so clearance from the CVC is required for all the government officials. Next is PM CARES Fund, that you all know that was in news during the COVID-19 time. So it's not a government fund, unlike the PM Disaster Relief Fund. It's not a government fund. Hence, the money does not go into the Consolidated Fund of India. But PM Disaster Relief Fund money goes into the Consolidated Fund of India. What is furlough and parole? So these things were in news also. So furlough and parole are converted under the Prisons Act of 1894. So it was introduced with a view of human prison system. Prison is a state service. So that why this system of furlough and parole was introduced? So that humanized prison system was there. There was basic human facilities or decent facilities available for the prisoners in the jail. In order to ensure that, this furlough and parole system was introduced. And prison, remember, as I told you, that flag comes under the residuary subjects. Prison comes under the state subjects. Okay, so what is parole? Parole is nothing but releasing a prisoner and meets specific exigencies. Suspension of the sentence. So whenever the suspension of sentence happen, during that time, for specific exigencies, for specific conditions, like he's not well or something on that side, that time parole could be given to a prisoner, and this is the parole is not given under the UAPA. If you are arrested under the Unlawful Prevention Activities Act, that time you are not granted a parole. Okay. Then what is furlough? Then furlough is granted to a person after a certain period of time without any reason. So suppose the prison authorities feels that the person who's been detained for some years, now he has a changed person, he shows good qualities and all those things. So what happens is the prison authorities can request the court, and as a result furlough can be given to that particular person without any reason, just that he has shown good qualities and there is no chance that he's again going to perform the same crime or any other crime. That time furlough is given. So in bracket also I've written, if any good changes are seen in the prisoners. Okay. Remission of sentence means remit the amount of duration. So suppose if 15 years of jail, 15 years of rigorous jail has been announced, or this type of punishment has been given to a particular criminal, so remission of sentence means reducing the tenure of the jail. That means previously 15 साल था, तो अब कितना कर सकते हैं? 7 years की jail उसकी कम कर दी, remit कर दी उसकी jail. Default, and it is also applicable for default or statutory bail. Internet shutdown, you have seen recently, it has happened many times in country. So internet shutdown comes under excuse me. Internet shutdown comes under section 144 of CRPC, okay, and the Telegraph Act of 1885, and as well as IT Amendment Act of 2008. So ये सब provisions के अंदर internet को इंडिया में shutdown किया जाता है. Remember, right to internet comes under Article 19, not under Article 21, because when fundamental rights are taken away during the time of emergencies, only Article 21 and 22 cannot be taken away, the right to life and personal liberty, but all the rights, fundamental rights could be taken away during the time of emergencies. So that is the reason right to internet comes under Article 19, not Article 20 and 21. Okay, and based on these acts, right to internet can be internet shutdown and right to internet of different people can be taken away. So during the protest for during the Citizenship Amendment Act protest, and when this lockdown was imposed on Jammu Kashmir, you have seen that internet was temporarily shut. Temporary suspension of telecom service, and these are the other rules where internet could be on these laws internet could be shut down. National Commission for Backward Class was initially set up as a statutory body, but after the 102nd Constitutional Amendment Act, it has now become a constitutional body. I hope this is clear. Next, when we come down to official language, it comes under part 17 of the Constitution. Okay, part 17 of the Constitution. And always remember, under the official languages, when we talk about the languages that are official language, that comes under 8th schedule of the Constitution. 8th schedule, as it talks about the languages. So there are 22 recognized language in the Constitution, and in the 22, English is not there. English is not mentioned, but Nepali and Hindi are there. Nepali and Hindi are there, and rest other 22 languages are also there. So just go through these languages once. But remember the fact that Nepali is also an official language of India, but English is not considered as an official language under 8th schedule. Always remember this. Scrillage and blasphemy means basically disrespecting the holy text. So Punjab government has urged the central government to bring out bail on life imprisonment for committing this crime. So recently, why this blasphemy and scrillage was in news? Because Punjab government has urged central government to make laws to bring out laws basically of life imprisonment if anybody who's committing this kind of crime. So blasphemy and scrillage is basically disrespecting the religious text. Public Accounts Committee was first introduced in the Government of India Act 1919. So there are different types of committee of the government in the Constitution. One, there are basically the division is based on two categories. One is ad hoc and one is permanent basis. So ad hoc committees are set up for particular tasks, and once the task is fulfilled, those committees are dissolved. But permanent committees are permanent in nature. So Public Account Committee is an example of permanent committee. Then again, there is estimate committees. Likewise, there are many other committees. Let's go through them once. Okay. So as you know, recently the farm laws were deleted from the Constitution. So they were taken away. So it's how act is how a bill becomes an act. There is a similar process to how to delete that particular act, and this provision is mentioned under Article 245 of the Constitution, where it talks about repealing and amending any of the act. Okay, so if you can amend or you can enact a law, you can also repeal it also. LIMS is basically Legal Information Management and Briefing System, that was in news. So it's a web-based portal department by Legal Affairs Ministry of Law and Justice. So what it does is basically it provides legal information management and briefing system on online basis, and it comes under the National Judiciary Data Grid e-court project. Basically, you can, because of COVID, you have seen most of the court cases were they were given future dates. So government has come up with this type of system where cases could be heard through online basis as well. Tele Law Initiative is again an online portal that gives legal advice from the lawyers. So now, because cases are being heard online, so lawyers' advice also can be taken online. As you have seen, there are different portals like Pacto and all these things. They provide medical, advice through online. You can consult a doctor online through Pacto and all these things. So similarly, there's a Tele Law Initiative where you can interact with a legal advisor, like lawyer, and take his advice if you have any kind of query regarding any, or if you have any problem as such. Next is inquisitorial system. Court are involved in investigating facts. So that is basically an inquisitorial system of courts, and Malimat committee recommended this thing, inquisitorial committee system. Faster system is talks about the fast and secure transmission of electronic records. So whatever records prove that have been submitted in a court while a case is being listened, many documents are also presented. So it should be recorded on an online basis so that fast and secure transmission could take place. So it talks about that as well. And third one is Supace portal. Supace portal was introduced by this Chief Justice Sharad Arvind Bobde, and what it talks about is makes relevant facts and laws available to the judges. So if a judge want to look at any of the previous judgment or any of the facts that are mentioned, because it's not practically possible to remember everything, they can use this portal and find out different facts and laws that are available for the judges to while giving a sentence. Next is e-governance. It's a tech support e-governance. So e-governance is basically online governance system. So you have seen many times the government have come up with different, different features, like you can get online credit, you can apply for your driving license online, you can apply for your Aadhaar card online, or you can avail any of the government services online. So that is basically e-governance, that is internet government, where you can sit at your home, apply for the service and get the service availed for yourself. So what is the reason behind how it has strengthened the institute? So more autonomy is given. So yeah, the e-governance there are different policies that have been taken by the government to ensure e-governance is taking place. Recent example is Delhi government, where they have launched Ghar Baith Ke you can avail the driving license facilities. Now there are different methods. If a question is asked, how can you strengthen an institute, or any other organization? So the first solution to strengthen any of the organization or an institute is by giving them more autonomy, that is decentralization of power, by financial inclusion or empowerment. If you give them more financial inclusion, if you give them more money, like involvement of multiple stakeholders. When multiple stakeholders are involved, even though the decision making takes time, but because many ideas have taken into consideration, so usually the end product is beneficial for the institute, following the international practices and focusing on output over outcome, not input. Okay. So next is NEGD, is basically talks about National E-Governance Division when they are talking about the this e-governance platform. So some of the example of e-governance are National E-Governance Division and Pragati, proactive governance and timely implementation of schemes. So what does this scheme does? Basically, it addresses common man grievance, monitors and reviews central and state programs. So it's a 3-tier system. We come down to Samvita scheme. Samvita scheme basically, it talks about mapping rural inhabited lands, settle property related disputes. So Samvita scheme talks about property related disputes, basically in the rural areas. IPC talks about IPC talks about, it gives the definition of a crime, and CRPC basically says what type of crime is committed. You can skip this part. 42nd constitutional, mostly the 42nd Constitutional Amendment Act. This was whenever we talk about the 42nd, it basically talks about centralization of powers by the central government. It happened during the Indira Gandhi. So even if you forget what happened in the 42nd or 44th, always remember when you're talking about the 42nd Constitutional Amendment Act, basically they are dealing with when Indira Gandhi was centralizing the power, and when we are talking about the 44th Constitutional Amendment Act, they are dealing with decentralization tendencies of the government, distributing of power post-emergency. Recently, RTI Judgment Act, CJI office has come under the RTI, right to information. So you can avail any of the information of the CJI office. Arbitration conciliation is done through legal entity, and mediation is done through non-legal entity. Basically, arbitration and conciliation is the resolution of any matter that has come up. Aadhaar is not a document for citizenship. You cannot use it for citizenship. Again, I told you. And issuing body which issues Aadhaar is UIDAI. Again, UIDAI is not a statutory body. Only government agencies can use Aadhaar authentication service, not private entities. Okay. Epidemic Disease Act has been amended several times. Recently, it was amended, to burden of proof. So you have seen the doctors were beaten up during the COVID-19 crisis. In order to protect them, this act was recently amended so that burden of proof of proving that a doctor was beaten up falls on the person against whom the complaint has been raised. And again, this is beating of doctor or committing any crimes against the doctor is a cognizable and non-bailable offense. Consumer Protection Act. So there are six new rights added here. Okay, RERA talks about property registration in each state. There's a dispute resolution body both for commercial properties as well as residential property. FEO, fugitive economic offenders, are those people who have taken the money from the Indian banks and fled the country. So if I give you an example of fugitive economic offender, Vijay Mallya could be one, and Nirav Modi could be one. So what is the criteria to become an FEO? So if the value of offense is over 100 crores, you will be considered as a FEO, as well as you have left the country and refuses to return back. Next is prevention of insults to Indian honor. So if you insult any of the national honor, it's a punishable offense, even though it comes under the fundamental duty and they are not justiciable. But insulting a national honor, it's a punishable offense. So flag comes under the residuary list and Article 51A of the Constitution, that is your fundamental duties. 97th Constitutional Amendment Act was added by cooperative societies concept was added under Article 9B of the Constitution, and cooperative society is a state subject. Remember this. So as of now, we have found 3 subjects, that is flag, cooperative society, and police. So police is a state subject, cooperative society is a state subject, but flag is a residuary subject. Next is corruption. There are two types of corruption: coercive corruption and collusive corruption. So what is the major difference between them? So coercive corruption talks about citizen compelled to pay bribe. So when you are compelled, you are being compelled to pay a bribe. That is coercive corruption. And collusive corruption is between bribe giver and corrupt public servant. Both parties benefit. So what I'm saying is, I go to a government office and I say I want to get a document. The person sitting on the office says, "Sir, you pay me 1,000 rupees, then I'll do your work." That is basically a kind of coercive corruption. But I go to the office and I realize that there is a very big line and the official is also busy. So I tell the official, "Okay, I'll pay you 1,000 rupees and you do this. You do my work." So that is collusive. We both are colluding together and doing this work. Hague Convention talks about flights and all, so it enforces hijacking convention also. So Hague Convention was in news, so that's what I have mentioned it here. The Ratan Vatal Committee recommended reviewing the autonomous body. National Crime Repository Bureau is basically a repository of crimes and criminals. Fingerprints of all the criminals are stored here. Again, one more statement about the CAG. I forgot to mention then that information from CAG report can be used by investigating agency. Why? While they want to press charges against those who have violated the law while managing the public finance. So recently, this was in news because in the Rafale deal case, the Congress members used the CAG